than that, you want to honor God.
This is Protestia Tonight.
Hello, you are watching Protestia Tonight, or listening to it, I suppose, for Tuesday the 31st of October, 2023. Happy Reformation Day for all of you still protesting Protestants out there with us. Thank you for spending your time with us. We're going to be discussing, by the way, this is the program that we hope will be glorifying to God, convicting the sinners, and edifying to the saints, a program with sincere questions, biblical answers. And today we're going to be talking about, tonight, I should say, we're going to be talking about the recent dust-up over the SBC's Amicus brief in Kentucky, or Amicus brief. Apparently I've heard it pronounced both ways. But either way, we're going to be discussing it and why. I don't know why they do this to me, but you got Bart Barber jumping in the mix, and he's falling all over himself, apologizing and forcing me to take the side of the Southern Baptist Convention. We try to call balls and strikes as much as possible around here, and often that has us calling strikes against the Southern Baptist Convention. But we're gonna kind of explain why the Amicus brief that they filed is, I would argue, entirely appropriate in this case, and exactly what they should have done. And we'll walk through it a little bit. We'll walk through Bart Barber's statement on the thing, and an article posted at Baptist News Global by Krista Brown and other abuse survivors, and we'll walk through that a little bit and just explain the issue non-emotionally from a sober and logical perspective, and explain kind of maybe some things that just people don't know about, or they're ignorant about the legal process, about the Southern Baptist Convention, about really what is the moral imperative of believers in this situation. Before we get into that, of course, a reminder, this program is brought to you by our intrepid patron supporters who for only $5.95 a month join us by going over to patreon.com/Protestia. For that, they get free, I shouldn't say free, ad-free, I should say, browsing on Protestia.com. They can log in with their Patreon account, and the ads magically disappear, making for a little bit easier reading experience. They get the full version of this program, Protestia Tonight, which includes the freeloader portion you are now watching or listening to, and the PT VIP portion, where they get to drive the content of the program by asking sincere questions on Patreon in the comments or in the messages. And we have some really interesting questions we're going to get into in the PT VIP this time around. Now, before we get into all of that, we want to talk about what really is Scripture describes as of first importance given to us as believers. That's the gospel of Jesus Christ. In 1 Corinthians 15, Paul writes to the Corinthian church, "Now I would remind you, brothers, of the gospel I preached to you, which you received, in which you stand, and by which you are being saved, if you hold fast to the word I preached to you, unless you believed in vain." Verse 3 says, "For I delivered to you as of first importance what I also received, that Christ died for our sins in accordance with the Scriptures, that he was buried, that he was raised on the third day in accordance with the Scriptures, and that he appeared to Cephas, then to the 12, then he appeared to more than 500 brothers at one time, most of whom are still alive, though some have fallen asleep. He appeared to James, all the apostles. Last of all, as to one untimely born, he also appeared to me." This is Paul outlining the gospel of Jesus Christ, which it starts with the bad news that you and I are born into sin, rebels against God, and on our way to hell, deserving of the punishment for our sins. And yet God so loved us, so loved the world, that he gave his only begotten Son, Jesus Christ, whom was born of a virgin. He lived a perfect life, earning righteousness on our behalf, and then stepped into our place and paid the price, the punishment for our sin that we deserved, so that we might be considered righteous by God, reconciled to him, and saved from eternal death into eternal life. And if you place your faith, hope, and trust in Jesus Christ, that salvation is a promise of God. Repent of your sins, turn from your wicked ways, place your faith in the sacrificial work of Jesus Christ and the righteousness he earned on your behalf as your Savior, and salvation can be yours. Now, Jesus died on that cross, paying that price. He said before he died, "It is finished." His work on that cross for those whom would come to faith in him and be saved was finished on the cross. He died, was buried, and on the third day raised from the dead by the power of the Holy Spirit. He resurrected from the dead, as Paul said in the book here, was seen by hundreds and hundreds of witnesses, resurrection being essential to our understanding of salvation. And then he ascended back to heaven to sit at the right hand of the Father and intercede for us. That is the gospel of Jesus Christ. And if you have questions about that, all this other stuff we're going to talk about really pales in comparison, pales in importance to the gospel of Jesus Christ. And we'll drop everything to talk to you about it if you have questions. Let's get into it. We don't have a ton of time here. And let's get into the issue here. So a few days ago, maybe a week ago, whatever it was, some news outlets reported that the Southern Baptist Convention joined an amicus brief or an amicus brief. You know, let's just pick a pronunciation. I'm going to go with amicus, and I'm going to go with maybe amici for like the singular. But an amicus brief is a document, a statement, a legal document sent to a court considering a case by a person or an organization or an entity that is not directly involved in that case, but has a vested interest in how the case turns out. And it's a statement of the court making arguments, really, for why the court should rule one direction or another. The term literally means friend of the court. It's Latin, but it means friend of the court. But these days, really, amicus briefs are used to for an interested third party or an interested party that may be facing a similar situation or a situation affected by the case that's in front of the court to weigh in and let the court, be aware of their arguments and why they find it concerning. And I guess this thing was filed back in April. So it was filed, over 6 months ago now. And Bart Barber, the current president of the Southern Baptist Convention, had signed off on the brief. And then when this came back out into the news, the abuse survivor folks and whatnot were very angry and upset that the Southern Baptist Convention would take a position against an abuse survivor. That's kind of how they characterized it. They didn't really. I haven't seen a lot of discussion among those folks about exactly what, the nitty gritty details of this thing. And I don't want to spend a ton of time getting, really deep and legal with it. I mean, it's as much as we don't have to do that and still get the point across. But I went through and I read the amicus brief and the reason that the Southern Baptist Convention, the executive committee, some of the entities, Southern, and Lifeway kind of had signed on as well to this. And I read through it, and I'd have to say I think that the Southern Baptist Convention is on the right side of this, not only legally but even morally on the right side of this. And what had happened, let's see if I can summarize this pretty quickly. What had happened was an appellate court in Kentucky, the Kentucky legislature had basically passed amendments to Kentucky law that would allow for the extension of statutes of limitations with regard to, basically how long after an abuse crime, a sex abuse crime and things happens, how long after that can a victim sue and seek financial restitution for what happened. And I believe the original statute of limitations was 5 years, and they extended it to 10 years. And there was a difference to be understood between extending the statute of limitations on an active case, something where the current statute, they were still within the current statute, extending that, and what they might refer to as reviving a dead case. So for instance, if somebody commits a crime of this nature and 3 years down the road, they're still within that 5-year statute of limitations and still able to sue, able to seek financial compensation for this, and then the legislature changes the statute to expand it to 10 years, that expands the time frame that they're in. So now instead of, say, having 2 years left within which to file a claim, to bring a legal claim forward, they would now have 7 years to do that. But there's a difference between that and saying, if the 5 years have expired, if the 5 years are past, so maybe you're 7 years down from when the incident occurred, when the alleged crime occurred, and then the legislature passes this expansion of the statute of limitations. Does that revive claims that where the statute has already expired? Now, the problem with this is if there's chatter that, hey, there might be a lawsuit coming against a perpetrator, or in the case of, and this is why the SBC is interested in this, the case of a third party, what they call a non-perpetrator third party, basically somebody that didn't commit the crime but may have had some responsibility to, say, report the crime, or they knew about it and should have done something. They're not the criminal. They didn't commit the crime themselves, but they might be on the hook. They might be liable because they were supposed to take responsibility in some way to at least report it to authorities or that kind of a thing. The problem is, let's just say that there are accusations that something has occurred, or there really are charges, and this will make sense, I think, when we start explaining this case of Samantha Kalari. I think it's pronounced Kalari. I think in the intelligence briefing last, I pronounced it Killary because it looks like Hillary, but instead of an H, it's a K. So I think I'd pronounced it Killary, but I'm pretty sure it's Samantha Kalari. This will make sense. I think when we start to explain it this way, her father and other people involved in her abuse admitted to the abuse and were charged criminally and convicted criminally. And yet in this country, there is a civil process as well. So even in a criminal case, I mean, a good example of this is O.J. Simpson was found criminally not guilty of the murder of his ex-wife and her boyfriend, and yet wound up being found civilly liable. He basically got sued and found that process found him with a preponderance of evidence responsible financially for their deaths anyway. And the same thing can happen in other cases. So let's say in the Kalari case, her father, the people that abused her, rightly convicted for those crimes. They admitted to those crimes or convicted of those crimes, and yet she also has civil remedy to seek damages and financial restitution for what happened. And sometimes that seeking financial restitution for those things also involves other parties that maybe could have and should have been responsible for bringing it to light. And if they had actually exercised responsibility like they should have, may have stopped the abuse or stopped some of the abuse, or the scope of the crime would not have been as bad. And so in Kentucky, like I'm in Colorado, but I'm going to try to, I think it's probably pretty similar around here. In Kentucky, there's a statute of limitations after which you can't bring a civil claim, a financial claim against even the actual perpetrator. And you can't bring a civil claim against a third party non-perpetrator. So this explains why the Southern Baptist Convention might be interested in these developments. But what happened was an appellate court in Kentucky had basically determined that this expansion of the statute of limitations from, again, I believe 5 to 10 years also included an expansion of the statute of limitations on non-perpetrator third parties, an expansion of from 5 to 10 years to be able to sue somebody who they didn't commit the crime, but perhaps they were responsible for reporting it or were involved in some way in the crime, continuing or being worse than it should have been. The problem you run into with this is non-perpetrator third parties, they know that the criminal activity and the criminal charges have been established. So they know that this has happened. They know that this issue has happened. And yet after the statute of limitations expires, they don't have any they don't have any motivation, or they would say, hey, we're not going to be found legally liable in any way for this. We're not going to be maintaining evidence. We're not going to be continuing to make sure that we kind of know what was going on and do our own research in which to defend ourselves. And then lo and behold, the government all of a sudden changes course and they say, oh, now the statute of limitations is 10 years. And you thought you were not going to be sued for this, and now you're liable to be sued again. It really puts any potential target of a lawsuit at a massive legal disadvantage, and I would argue an unrighteous disadvantage. It's wrong to lie to somebody that way, to say, hey, you don't have responsibility for this, or at least the victim is not going to be suing you for this. And flip it and say, oh, now they are going to be suing you for this. Let's dig in a little bit into exactly what happened here. This is the actual amicus brief itself. Let me see if I can pull this up here. This is the brief itself, file that looks like it's a little sketchy, but it looks like April 5th, 2023. And this is, let's see, they're filing this verse on this appeal from Samantha Kalari, and they state their interest in it because, as a potential third party target, I guess, of the lawsuit, if we could say it that way. They're seeing the ground under this move as they're trying to perhaps defend themselves or understand what they were supposed to do or not do. And so they say right here, I've highlighted a few things that I hope can make this clear. Amici or Amici. This is the entities, the Southern Baptist entities that have sent this to the court together. It says they have a strong interest in the statute of limitations issue presented in this appeal. So the appeal here, by the way, is in front of, and I'm pretty sure it's still in front of, the Court of Appeals of Kentucky. And the appeal looks like by Rick Jackman, Louisville, Jefferson County Metropolitan Government, and Linda Thompson. So it looks like this is the authorities versus Samantha Kalari, but basically within the appeal, and I don't have the appeal sitting here in front of me, but as far as I understand, it has to do with being able to, in her case, Samantha Kalari is suing these non-perpetrator third parties, Rick Jackman, Louisville, I should say. It's Louisville in Colorado, but in Kentucky, Louisville and Jefferson County Metropolitan Government, and Linda Thompson, who is like a family member or a church member or something. And Samantha Kalari is basically saying, I'm suing these people because they knew about my abuse and didn't say anything. It was reported to them and they took no action. They're a non-perpetrator third party. And the appeal here is basically these guys saying the statute of limitations on this has expired. Like, you can't sue us because the statute of limitations had expired by the time you decided to do this. And then Samantha Kalari is saying, no, the Kentucky legislature has extended the statute of limitations on civil cases against abusers. And the Court of Appeals here has apparently determined that extension of the statute of limitations extends to non-perpetrator third parties. So now they're back in the crosshairs, so to speak. Legally speaking, they're back in the crosshairs as far as getting sued for this, apparently or purportedly not reporting what they knew about the abuse. And the SBC is like, this is problematic. If Kentucky is allowed to extend the statute of limitations to non-perpetrator third parties in a way that would revive old cases, now that the SBC may be on the line for a bunch of stuff that they would argue, and I would argue as well, that they're not going to really have the ability to defend. There are rights established by a statute of limitations to say that once a purported crime or once a purported issue that you might be sued for is far enough in the past, you really lose the ability to defend yourself. You lose the ability to actually mount a proper defense of what was going on. I mean, memories are hazy, evidence disappears or is lost or kind of blurry, or it changes. And we're not talking about a criminal court here. We're talking about a civil court where the standard is lower. The standard for a criminal court is supposed to be that you are found guilty beyond reasonable doubt. In a civil court, it's you're found responsible by a preponderance of evidence. Again, like with OJ, found not guilty by the criminal court and yet found liable civilly for the same thing that he was found not guilty of in the criminal court, and had to pay out. So you have this combination of the legal standard for your responsibility being lower, at the same time saying we're going to be okay with you being on the hook for this for a much longer period of time. And in this case, a period of time that you didn't think that you were going to be targeted for responsibility or held responsible or have to defend yourself in some way. And then lo and behold, later they revive it and it comes back and nope, now you're on the hook. Now you might get sued for this. I mean, you can. I hope you can understand why this is not a proper or righteous legal standard, no matter what you think about the validity of any claims being brought against the SBC at this point. As far as I'm concerned, that is a different matter, and it is not biblical justice to say, well, because we have a certain outcome, we want to be seen as supporting abuse victims and that anything is fair game to get this done. It doesn't matter if it actually is just in terms of its process. And we saw this. I mean, we saw this earlier, didn't we? With the Southern Baptist Convention's executive committee waiving attorney-client privilege, which is just, I mean, it's dumb, and it really was sinful as far as their responsibility to the giving for ministry of Southern Baptist churches and Southern Baptist church members, to say we're going to assume. Let me see if I can explain this straightforward. When you say that you're going to waive attorney-client privilege, you're basically making the assumption that whoever's going to bring a case against you is 100% telling the truth. They have 100% righteous motives. You're basically surrendering any defense you might have, no matter what the person bringing the accusations against you happens to be saying or doing, or what their motives are. And that's the reason that the law firm that has represented the executive committee for so long said, we can't have any part of this. We can't even do our job for you if you're going to say, automatically say the other side is right about everything. Whoever's bringing the accusation against you is automatically right. Like that lawyers can't do their job in that case. And I want to make this clear as well when we're looking at this brief. This is basically the law firms representing these organizations doing their jobs. Their jobs are not to do whatever their clients say. Their jobs are to exercise the strongest legal defense of the case of their clients, no matter what. That's the job of a lawyer. So you see these people all over social media right now saying, I saw this from Jacob Den Hollander, Rachel Den Hollander's husband, running around complaining that, well, I can't believe, that lawyers work for the clients, right? So if the client says the lawyer's not supposed to do something, they're not supposed to do it, dude. Like, I think, aren't you a lawyer? Your wife's a lawyer. I know that. Like, you don't understand that is a violation of the legal responsibility that a lawyer has to their client. Your job as a lawyer is not to do whatever your client wants. The reason that they hired you is because they don't have expertise in this area. Your job is to defend them ethically every way that you can. Because the way the process works is the lawyer on the other side is going to do everything that they can. They're going to do everything that they can to defeat you, regardless of how good of a case they necessarily have. That's the way that our system works. This isn't, let's all take the guardrails off, assume that the other side will do likewise, and we'll just sort of work it out. That's not the legal process in this country. And if you as a lawyer say, okay, client, I'm going to, I mean, you have no idea what you're talking about. You don't know law. You don't know this process. You hired me to defend you, but you think you know better. And after all, I mean, people on Twitter are accusing you of being a bad guy for not supporting abuse victims. And I mean, they're comparing you to Catholic Church, priest molestation and all this. So because you're really worried about how you look in the public relations sphere, I'm going to let you be the lawyer instead. And I'm just going to sort of sign off on it. Like, no lawyer should ever do that. It is a complete abrogation of their duty. And yet we still have Southern Baptists out there and interested parties saying that that's what should be done. It's baffling to me. And we look at this amicus brief. This is lawyers and law firms for these institutions here making a proper case for the being innocent until proven guilty. That's all they're doing. They're saying we can't have a statute of limitations for suing non-perpetrator third parties that's expanded and then revives old cases. That's not what the Kentucky legislature did. So we're going to argue against the appellate court's interpretation of this. So they're making this. This is submitted to the Kentucky Supreme Court and making an argument that Kentucky law does not allow you to the Constitution of Kentucky that basically says that citizens and organizations and things like this within our state have rights, and then have the appellate court make a ruling on this that effectively yanks those rights away retroactively. That's really what they're saying. Scrolling down here, I have a couple other highlights that I wanted to discuss real quick. The Southern Baptist entities said that they don't dispute the laudable policy reasons for providing relief for victims of childhood sexual abuse. And for the record, of course, neither do I. But not even the most sacrosanct policy can trump the clearly expressed legislative intent and fundamental due process concerns presented in this and similar cases involving the attempted retroactive application. So this is Kentucky Revised Statute 413.249 to expired claims. So they're saying, hey, expanding the statute of limitations here, not only should it not be reviving potential claims that have expired, because again, like I previously explained, that violates the due process and the ability of someone who's being sued to defend themselves. And we believe in due process. We believe that people are innocent until proven guilty, and that even in a civil process, it's not about how bad we can make you look PR. It's about the truth behind what's going on. There has to be a due process that maintains that regulates that discussion, obviously. But they're saying that not only does this expansion of the statute of limitations, not only should it not revive previously expired statutes of limitations, but it especially shouldn't do that against non-perpetrator third parties. And I agree with that legal interpretation. Even those who are accused of being complicit in some way, those who are accused of dropping the ball in some way in sex abuse cases, they still have a right to defend themselves. That includes the Southern Baptist Convention. And yet we have had for some time now a certain contingent of people in the SBC, and I don't know if it's for power or influence. I suspect that's part of it. It can be for their collectivist and Marxist tendencies at this point, where, I mean, we had a lot of voices in the Southern Baptist Convention that are basically all on board with collective justice, social justice, the idea that everybody should be grouped together and held morally responsible for something as one group, which is not biblical. It's almost like they are happy to watch all of the missional giving and what they purportedly support about SBC ministries to burn to the ground on so that they can take the supposed high road and virtue signal about how much they support abuse victims and abuse survivors. And there's not justice. Biblical justice is not about getting even or getting compensation from anybody and everybody. It's about holding perpetrators actually accountable. And unfortunately, we have a standard here. I mean, you see these guys all the time on social media or on the convention floor, basically walking up there to say how all of us are responsible and we have to take responsibility and fall on our knees before the Lord to repent of this and I'm sitting there like I didn't abuse anybody. I'm not going to. In fact, it would be sinful of me to claim that I can repent for the sins of somebody else, that I can somehow pay for the sins of somebody else. That's not justice. It's never been justice, biblically speaking. But it certainly makes for a good virtue signal. It certainly makes it, really, really strategic for someone like Grant Gaines or Todd Bankert or any of these other guys to stand up at the convention and say, see, I'm the biggest supporter of abuser. I support them so much that I'm going to advocate for all of you that didn't do this to pay for it. That's what's going on right now. And it's not a biblical standard for justice. It never has been. And yet with this Amicus brief coming out here, that's what we're hearing again. You see it over on, and Bart Barber finds himself caught in the middle of this because number one, the SBC president's not an officer of the SBC, believe it or not. Like he actually doesn't have like governing authority in the interim between meetings. That's for the executive committee. He's more like a figurehead, and then he's like the guy that sort of like runs the show when the SBC gathers 2 days a year. And he makes that clear in his blog response, which, by the way, totally irresponsible way, considering that the world around us seems to think that the SBC president runs the SBC. Like, if you know anything about the SBC, you know that's not true. But because the world thinks it, apparently that's what we're going to go with. And in that light, like in response to what could be a very potentially damaging and risky situation in which he finds himself, he doesn't go get a lawyer to say, what should I say here? Am I saying this the right way? He jumps on his blog and sort of just casually chats it out, and not realizing that the lawyers and those who are trying to sue the SBC for all sorts of reasons, mainly in a lot of cases to get to the money to pillage the cooperative program, they're going to take his statement here and use it in court. I mean, anything you say can and will be used against you in a court of law, and everybody thinks Bart Barber represents the convention. That may work in a court of law. I mean, we've had courts who have continually failed to understand that the convention is not a hierarchical governing body. The convention is it's a cooperation of churches. I said, I think on Twitter a couple of days ago, this would be like if at your local TV store, people kept getting beaten and robbed in the aisles of the local TV store, and the store knew about it, and the cops knew about it, and they find the perpetrators for this, and then the victims turn around and sue Sony or LG or Panasonic or something, and they say, I also sent an email to Sony saying that this was a problem, and you guys knew about it too, and after all, this TV store sells Sony TVs, so I think you're on the hook for this as well. That's kind of what we're seeing with the SBC. Like, the SBC doesn't run churches. The SBC doesn't have authority over them. Churches and really the members, I would argue, even more directly, have authority over the SBC. And so when an abuse situation happens, awful situation happens at a local church, the Southern Baptist Convention doesn't have the ability. We've talked about this before. They don't have the ability. They don't have the call. That would be way out of their lane to claim that they can judicially do something about it. And yet these guys on the platform, they want to have it both ways. They want to say on the one hand, these are autonomous churches. We can't do anything judicially about this. And yet on the other hand, they want the virtuous credit for saying they're doing something about it. I mean, that's why we have talk about having a, like a database and why we got like a Caring Well website and resourcing churches to handle these things. None of that is bad necessarily. I mean, I would argue the database is, I mean, a database of people that haven't been convicted of anything should cause us all to have pause. Like that seems like a problem. But certainly resourcing churches on how to handle these things, that's not bad in and of itself. But we have to be very, very careful, and they haven't been, and this is the problem, with drawing that line, delineating between this is advice we're giving, resources that we want to provide, and yet we don't have authority to actually literally do something here. And again, they want it both ways. You got these platform guys that are more than willing to let the world think that they and the SBC and SBC leaders somehow have the ability to do something here, so they can pat themselves on the back and show everybody how virtuous they are for doing something. And yet when the rubber meets the road, they still want to be protected by the legal process with things like this amicus brief, which again, I think is a good brief. And actually I agree with the SBC entity's take on this. Due process is essential, and we have no biblical call to remove due process, for an end goal. We're Christians. The ends don't justify the means. We don't find somebody that's been accused of a crime and execute them on the spot. And then we'll figure it out later if they actually did it. We have a process for it, and it's not a Christian position. It is not a position that's supported at all by our legal system, by the English common law that it comes from the biblical common law that comes from, to say, because we have a message we're trying to get out to the world, we're trying to desperately make the world understand that we support abuse survivors, we'll do anything and everything to make that happen. That's not Christian. The ends don't justify the means. If it is a righteous end, it can be attained by righteous means. And that specifically includes due process for anybody involved. Anybody involved. I don't care how emotional you are about hearing about something bad online. That never gives us the right to say we're going to automatically assume that person's guilty. We're not going to go through a process. By the time we even get to the process, we'll have smeared them all over the internet. It's not it's not right. It's not the Christian way to do it. And I know there are going to be people that say, "Oh, that's what Protestia does all the time. You guys smear people all the time." No. We bring the receipts, and we endeavor very, very hard to never make claims that are unsupported by what we put on the website. And of course, we, like I've said this before, we always invite challenge. If you think that we've gotten something wrong, especially factually, if you think we've gone a research a fact wrong, I mean, you can take issue with my opinion about whether this amicus brief is right legally and morally all day long. Fine. I mean, I'm clearly offering my opinion and my views on it, hopefully supported by evidence. But it's never okay. And this is why the SBC is in the play when they could have made the hard yet righteous decision of saying, this is what we believe as Baptists. This is what we believe about law and jurisprudence as Baptists. And so, the world is going to hate us for this position, but we are going to insist on due process for everything here. We're going to insist on the civil magistrate who bears the sword for this purpose being the place that this happens, and the local church, of course. And we're going to stay out of it because that's not our lane. When they could have taken that position, instead, you have leaders in the convention like named leaders like Grant Gaines and Todd Bankert. I mean, just to name a few, and Bart Barber to an extent, and a bunch of these guys deciding that we want to look virtuous to the world. So we're going to throw out, we're not even going to attempt to defend the validity of this being a cooperation of autonomous churches and not a hierarchical denomination like Roman Catholicism. We're not even going to attempt to defend that. We're just going to climb over each other to see if we can be the ones at the mic to really emote and make sure everybody knows how much we care and sympathize. That's what they did. And it comes back to bite them. And now we have Bart Barber doing the same thing. He's doing the same thing right now with this explanation here. So this was posted yesterday, and he said, last week a reporter published a story about an amicus curiae brief that the SBC joined in a Kentucky sex abuse case. Many of you have wanted, and again, I mean, we talked about it before, but this is an appeal that we're seeing here. This is an appeal by the targets of the lawsuit by Kalari here, saying we don't think this should be opened back up against us. But we talked about this before. So he said many of you wanted me to make a statement about this brief. I should have said something long before today. So I mean, I'm so glad that I didn't. Okay, so apparently it sounds like people have been wanting him to make a statement for a while. I'm not sure. You see, if I had given you a hot take, if I had commented immediately, I would have said, what are you talking about? I don't know anything about Amicus brief. But like, if you forgot about it, that's okay to say that. And people will be like, well, dude, you signed on to it. And be like, oh shoot, I did sign on to it. Okay. Yeah, let me explain why I did that. Over the weekend, I found the email where I approved the SBC's participation in the brief, which I've argued he should have done. He said, this is my doing. I approved it. I take full responsibility for the SBC's having joined this brief, and this lengthy statement will help explain the mistakes I think I have made. Like, I just got through explaining to you why I don't think he made a mistake to sign on. This is the mistake that you're seeing here, because Bart Barber has realized, oh man, the world around us and the PR for this is bad. And I mean, we won't even attempt to actually explain why we did what we did in terms of biblical justice here. We won't even attempt that. I mean, there's no way that we're not going to get tarred and feathered by every abuse survivor blog out there in the world, and Christianity Today and every other place is going to give us a hard time. So I guess we better bite the bullet now. And now we have this answer from him. He's saying, I know a lot of people are disappointed and angry. I've talked about friends I'm talking about friends I've had for 2 decades, survivors of sexual abuse for whom I have wanted to be an advocate. Now, I mean, he's already sort of giving up this idea that it's possible that those who are survivors of sexual abuse may be targeting the wrong perpetrators. It's also possible, until the process happens, that there may be survivors of sexual abuse that wind up not actually being survivors of sexual abuse. I know. I mean, I know that the zeitgeist and the culture of the day is believe all women. And if you can get people to emotionally side with you, you've basically won. But that's not how Christians are supposed to do it. And yet he's giving that up right here. He said, I'm talking about people I appointed to carry forward the SBC's response to the Guidepost investigation. Again, quick reminder, the Guidepost investigation very clearly demonstrated that there was no systemic cover-up of sexual abuse in the Southern Baptist Convention. Very clearly demonstrated that. I mean, like, the most salacious stuff they had is still, to this moment, hotly contested. The Johnny Hunt thing, hotly contested as to, still to this day, about who was responsible for what. It certainly wasn't sexual abuse by any stretch of the imagination. The Jennifer Lyell thing, still contested to this day exactly what the nature of that was. Now, in the modern framework of being trauma informed, where the subjective interpretation of what happens is to be taken as fact, and in fact, if somebody comes along and objectively disproves the allegation in some way, or parts of the allegation in some way, we can say, well, the victim was so traumatized, they just didn't remember it correctly. The victim was so traumatized that they're not a reliable source in terms of actual logical nuts and bolts facts. So we're going to take their emotional reaction to this as fact instead. That's the culture and the sort of the atmosphere and the legal situation and legal culture in which we find ourselves. And I mean, this response from Barber is just proving this. People saying, Bart, what were you thinking? It happened in August 2022. So this amicus brief, I guess, was in August of last year and not submitted to the court until it looks like April of this year. That's pretty normal. Legal stuff, I mean, it drags out. He announced the appointment of the Abuse Reform Implementation Task Force. This is the second task force. The first one was like, all right, what are we going to do? And then they get they commission guideposts to investigate. This task force is okay. Now that Guidepost has given us their report, what are we going to do about it? Right. That night, I released a video responding to the heated criticism I had received for appointing Todd Benker to that committee. Yeah, you were rightly criticized for that. Todd Benkert was one of the last people that should have been on that committee. Then we're in he says he's in Nashville, yada yada. I mean, this is so wordy, and I mean, yeah, appealing to I felt this, I felt that. No discussion of the actual content of the brief, as far as I can tell. Yeah, filing deadline was that day. He had a little more than 3 hours to reply. Yeah, I mean, he's kind of making excuses for this at this point. And the funny thing is, like, he did the right thing. Like, if he had just stepped back and instead of trying to offer a PR response, had actually made an argument for what he did, it would have been a much, much better strategy. So, legal work, not his favorite part of the SBC presidency. When I'm asked to sign an affidavit, I read from start to finish, simply asked, do I know all these things to be true? If so, I sign it. I don't recall my exact thoughts. And again, I got to get back to I maybe he was required to sign off on it. I don't know, but the SBC president is not like heavily involved in what goes on in the SBC. I mean, I know people find that hard to understand or believe. Yeah, I mean, he says it here. The executive committee of the SBC, not the convention president, is empowered to act in the convention ad interim. That's in between the meetings. The consent I gave on August 9th, he meant to say 2022, was consent that I gave in coordination with the decision made by the interim CEO of the SBC executive committee to join this brief. Of course, that was Willie McLaurin. Made up resume, Willie McLaurin, right? The messengers have not voted on any of this. Does it even lie within the power of the SBC president to make decisions about amici curiae unilaterally on behalf of the convention? I think probably not. Okay. I mean, it's good that he understands that. I think that the president of the SBC is obligated to execute those decisions as he is if the messengers had voted on the matter themselves. Okay. So then he starts opening. Then he makes the emotional appeal. Well, what about Samantha Kalari? Yeah, she's entitled to due process just like everybody else, and we pray for justice in her case and every other abuse case. Absolutely. I'm not sure exactly what to think about statutes of limitation. I think they're a mixed bag. Well, you signed to a brief that said that you didn't think they were a mixed bag. I guess maybe you should have read it more carefully, but and he really says he says later in here about his line of thinking. Man, this is just so wordy. It just goes on and on and on. Yeah, this is kind of concerning to me, to be honest with you. Throughout the last year and a half, so many of you have told me that you are praying for me. Okay, nothing wrong with that. We should be. I can tell by the looks of your faces that some of you think I'm joking when I reply, please keep praying for me. Please keep praying for me, because every day I make decisions for you that I do not know how to make. Okay, let's read that again. Because every day I make decisions for you that I do not know how to make. Counting on your prayers, counting on wisdom from above. So, I mean, if he's talking about, through the Lord's strength, this is done, not my own strength, I would agree that that's how it should be done. But it's concerning if you say something like, I'm making decisions, and these are decisions that have massive ramifications, potentially. Massive ramifications for the stewarding of the resources that God has given Southern Baptist churches that they contribute for cooperative ministry, and he's making them decisions that he doesn't know how to make. I mean, it seems to me like he's admitting incompetence here. And the worst part is, like, in his incompetence, apparent incompetence, he made the right decision, I would argue, to support this brief. Now, of course, we go over to, we're running out of time here, so I'm going to try to speed this up a little bit, but we go over to here to this opinion put up 4 days ago by Krista Brown, David Clohessy, I think that's how he pronounces it, and Dave Pittman. These three folks here, some of you know Krista Brown as being one of the sex abuse survivors from the SBC, kind of leading the charge on a lot of this. So first they argue in this case, and this is the amicus brief we're talking about, the SBC decided to insert itself, even though the SBC is not a party and the case has nothing to do with the SBC. Like, guys, okay, that's what an amicus brief is. Like people don't file amicus briefs if they're a party to the case. Then they just file motions. Like, I mean, I guess, are you assuming that people can't figure this out? Yeah, sorry, it's just kind of such a dumb statement. So they're saying that the court, that Lifeway Christian Resources and Southern Baptist Theological Seminary, the executive committee, is urging the court to throw out Kalari's lawsuit, arguing against Kentucky laws that would allow child sex abuse survivors to seek justice. Now that's not a good description of what's going on. That's an emotional, exaggerated description of what's going on. The SBC and the amicus brief is saying we would like you to throw out, or we argue that it is not legally appropriate to use this change in the statute of limitations to revive expired claims against third party, non-perpetrator third parties. And I agree with them. And yet we get this very emotionalized version of this. This is a Kentucky law that will allow child sex abuse survivors to seek justice. Now, Kalari's perpetrators are in prison right now, right? The people that actually abused her are in jail. They admitted it; they're in jail, so that's justice as far as I'm concerned. This is suing non-perpetrator third parties, which she had every right to do within the scope of when this happened. I know some of you are going to disagree, and say, well, I think the scope should be infinite. She should be able to sue him anytime she wants, forever and ever and ever. Okay, I mean, we can have that discussion if that's appropriate or not. But characterizing it this way is doing readers of this article a grave injustice by not explaining the details. So they're saying that the SPC is trying to negate the Kentucky laws. No, they're not. They're actually trying to explain why the changes don't actually agree with the Kentucky Constitution. 8 lawyers from 4 different law firms signed off on the brief because that's their legal responsibility to act in the best interest of their client, in accordance with what is ethical, of course, but there's nothing about that brief that's unethical. Not a single thing. It's only wrong if your framework is emotional PR. If your framework is, have you ever heard somebody say something like, if it'll save one, like with gun control, if it'll save one life, then we got to do it. And it's just an emotional, non-objective absolute. And this is the same way. Well, anything we got to do to let abuse survivors seek justice, we got to do. Throw your lawyers out. Waive attorney-client privilege. Let them do whatever they want. And any money that comes to the SBC, if it would make them feel better and help them seek justice, you should do it. That's not justice. It's never been justice. And yet it is over and over and over again, these kinds of emotionalized, non-biblical, non-judiciable arguments made by the abuse survivor community. They say, they blame, the brief cost money and they shouldn't have spent the money on the brief, and said, this is how SBC officials are using offering plate dollars, not to help abuse survivors, but to attack the possibility of justice, even in a case that doesn't involve them. Again, that's what amicus briefs are for. It's if that case is going to be pertinent to a case you are involved in. And that's the first thing you have to explain on the brief is this is why we have an interest in this. I feel like I'm taking crazy pills reading this kind of stuff. Seriously. So they reference Hannah Kate Williams' lawsuit in the brief, stating that there are non-perpetrator third parties who were allegedly made aware of the abuse and violated common law duties in responding to it. And again, allegedly, right? And then these guys tell you, well, read that law again, as if that's somehow like an admission of guilt. It's not an admission of guilt. And it claims that the SBC is throwing all child sex abuse survivors under the bus. No, that's not the case. The SBC is not arguing against the expansion of the statute of limitations to 10 years. They're not arguing against that. They are arguing against it retroactively reviving potential claims against non-perpetrator third parties. In dealing with sexual abuse, the XPC's primary driver remains the same as it's always been, protecting against institutional liability risks. That's their job, actually. The safety of kids be damned and justice for SBC2 survivors be damned. Like, no, hold the people who are accountable. The people that committed the crime should be held accountable. It was not the SBC. It's not other churches. It's not everybody else all over the country. This is not difficult to understand unless your method of interpretation here is strictly your emotions. Now, I know it sucks to step back from your emotions. Like, you want vengeance. You want to get back. You want justice. But this is not the way to go about it. It never has been. So, yeah, they go on to this. They say near the end here, merely withdrawing the brief is not enough. Like, I wouldn't withdraw the brief. It's appropriate. The brief is appropriate, considering Kentucky law and considering that due process is a biblical value. They said they still would benefit from it because once filed, a brief can't be unseen. So just the mere presence of the argument is damaging. Like, this should be censored. People shouldn't even be able to consider the argument made by the law firms of these SBC institutions for due process. People shouldn't have even been allowed to hear that. So they go on to write, if indeed the executive committee is remorseful about the brief, then it needs to affirmatively disavow the brief. Now, if I'm one of these lawyers that has studied the law, studied why this is a dangerous precedent to set, and I'm not a lawyer, don't take legal advice from me. Go seek an actual lawyer if you're in trouble, obviously. But if I'm a lawyer for these groups, and after I file this brief, after having done all this research and believing and being able to defend the case, they instead say, "Oh man, the media is really dragging us on this, and people on Twitter are really dragging us on this. We can't have this, and so we're going to throw our law firms and our lawyers under the bus and say, oh yeah, they really shouldn't have done that." Like, I would refuse to be your lawyer anymore. I'm going to quit on you because I did exactly what was in your best interest, what was ethical, and what I believe was the right thing to do, legally speaking. And because of social media pressure, you're going to ruin all that work. I can't defend you. I can't represent you if you're going to do that kind of thing. Again, this is why the law firm that had represented the executive committee for so long quit on them. It's like, we can't represent you if you're not going to follow our legal advice, especially at the core level. The core level of what we talk about as your representation with you remains with us. A standard of legal activity and jurisprudence since the dawn of time. You're going to throw that out the window. I can't represent you. We're out. And that's what they did. See if there's any more about with this. They said, if the SBC Executive Committee's Seminary Lifeway actually care about justice for SBC2, they need to withdraw their brief, submit a new brief in support of the extension of limitations for child sex abuse survivors to seek justice against both their perpetrators and, get this, enabling institutions. So again, it's imprecise language here in order to emotionally to tweak your emotions. These institutions enabled this. They enabled this. Well, you don't know that yet. But again, even institutions have legal rights to not have to be looking over their shoulder from now till the dawn of time about a possible lawsuit that by the time it comes around, they may not be able to defend themselves against. Due process is a right, and the accused have rights too. They say, short of that, it's all posturing, grandstanding, and window dressing. Okay. I think you've gotten the point. Hopefully this hasn't bored you too much, and hopefully has been helpful. Stay tuned if you are watching this or listening to this on Patreon and you are a patron of this program, because we're going to go right into the PT VIP for those of you freeloaders out there on YouTube or other places. Consider joining us, patreon.com/Protestia. As always, leave comments and things if you think we've gotten something wrong. can't promise you I'll get to them all. For patrons, I guarantee I will get to them all. That's kind of how it works. Thank you again for watching Protestia Tonight. Have a good rest of your week. As always, Semper Reformanda.